Samuel Hill, file 26-7155FH for arraignment. And for purposes of arraignment, is a forensic center referral requested?
It is not, Your Honor.
Okay.
Actually
like...
provided to the court 3 different documents. One would be an executed plea agreement, the other a device of rights, and then third being a no contest plea, the affidavit of probable cause. The basis for the no contest plea would be civil liability and diminished recollection. The court may be aware that a civil matter, Hill v. Hill, was heard yesterday in front of this bench for, I think, entry of proofs for divorce.
All right, and Ms. Good, would you consent to the entry of a no contest plea?
Yes.
Okay, Mr. Hill, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down. You and your lawyer can be seated if you wish. Mr. Hill, a guilty plea hearing is an important event. I'm sorry, a no contest plea hearing. It includes the waiver of constitutional rights that you have, so I want you to listen carefully. If you have a question, ask me. If you need more time to talk to Mr. Filippo, you just say so anytime. So first off, do you understand that a no contest plea has the same legal effect as a guilty plea in the criminal case, meaning you would stand convicted of the offense and I would have the jurisdiction or authority to sentence you for it? Do you understand that?
Yeah.
Okay. The charge of domestic violence third offense is a felony. It carries a maximum of 5 years in prison and or a $5,000 fine. Do you understand that maximum penalty?
Yeah.
You on probation or parole anywhere?
No.
Were you on bond for any other case at the time of this incident? Did you read and understand the advice of rights form and signed it?
Yeah.
Do you have any questions for me or Mr. Filippo about any of those rights?
No.
Do you understand if you enter a no contest plea, you give up all those rights and won't have a trial?
Yeah.
Is that what you wish to do today?
Yeah.
If I accept your plea, you give up any claim that the plea was caused by threats or by any promises that aren't put on the record today. Do you understand that?
Yeah.
Also, when you enter a no contest plea, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do so by filing an application, but the types of issues you could raise on appeal after pleading no contest are very limited, much more limited than, for example, if you were convicted after a trial. Do you understand that?
Yes.
The agreement provides in exchange for your plea to count 1, the domestic violence third, the prosecutor will dismiss the habitual. And there's a sentence agreement for no immediate jail. There'll be probation terms set by the court. Of course, if you violate probation, then there'll be jail, but there's no upfront jail. Do you understand that?
Yes.
Mr. Filippo, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Hill, that sentence agreement for no jail is not binding on me. If I get to sentencing and read the pre-sentence report and think I want to send Mr. Hill to jail, I don't have to follow this. But if I didn't follow this agreement, you'd be allowed to withdraw your plea because you wouldn't be getting what you bargained for. Do you understand that?
Yes.
There is an important exception to that rule. If you engage in misconduct between now and the sentencing, let's say you violate the terms of your bond, conditions of your bond, or you don't show up for court or abscond on your bond, or you commit a new crime, then by that misconduct, you'd be losing the right to withdraw the plea, even if I didn't follow the agreement. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you plead no contest?
No.
Has anybody threatened you to make you?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge of domestic violence third offense? Guilty, not guilty, or no contest?
No contest.
All right, and I have reviewed the affidavit, the complaint and affidavit marked as joint exhibit number 1. I do find it establishes a factual basis for the domestic assault that occurred back in October of 2023 that was reported at a later date. Mr. Hill, at the time, back in 2023, did you have prior convictions for domestic assault in the 89th District Court in 2001?
Yes.
And in the 90th District Court in Petoskey in 2011?
Yes.
All right, Mr. Filippo, are you satisfied with the factual basis?
I am satisfied with the factual basis, Your Honor.
Ms. Goodrich?
Yes.
Mr. Philippa, are you aware of any other promises, threats, or inducements?
Not aware of any promises, threats, or inducements not disclosed on this record.
And do you believe I've complied with MCR 6.302?
You have, Your Honor.
Ms. Goodrich, do you agree with both those propositions?
Yes.
All right, Mr. Hill, I find that your plea of no contest is knowingly, voluntarily, and understandingly made, and that there is a sufficient basis in fact and law for me to believe that you are guilty of that violation. So I hereby accept the plea. We could schedule sentencing, Mr. Philippa, for the afternoon of June 2nd at 1:10 in the afternoon. Would that work for you?
I think it would, Judge.
Okay.
As far as you know, you have a cardiologist.
Okay. And Mr. Hill, you'll have to cooperate with the pre-sentence interview and report. So I want you to stop by the probation department before you go and tell them you entered a plea. See about getting that in motion. Now, I also want to indicate during the divorce proceeding yesterday, there was some mention through counsel at that hearing that there may be some requests that Mr. Hill would have for a temporary change to his bond conditions to facilitate something in that divorce case. Did he talk with you about that, Mr. Philippa?
Ms. Zukla did call and speak with me about that. I've spoken with my client as well. The bond from district court talked about one civil standby to retrieve some items of property that are still at the residence.
So there wouldn't need to be an amendment of the order to facilitate that.
Well, I think there was a single civil standby. That's already happened once.
Okay.
So whether, I'm not sure anyone's going to complain, but we certainly don't want to. We want to be proactive on that. If bond can be amended to allow a second civil standby or a second opportunity to return to the marital. I guess it's no longer the marital home because I think she got the marital home yesterday. But
Okay.
To retrieve items that are at that property.
Okay, Ms. Goodrich, any objection to amending it to allow an additional civil standby?
No objection. We did notify the victim that she may be contacted by law enforcement for a second civil standby.
I think she's in the back of the courtroom in the green. Well, in that green,
Okay, well, I'll indicate in the on the scheduling order that bond is continued and is amended to allow a second civil standby. If everybody's comfortable that handwritten written order suffices, that's fine. If you want to submit some stipulation order, I would sign that as well if you see the need for that. Okay, anything further from the defense?
Oh, Your Honor.
Anything further from the people?
Yeah.
Okay, Mr. Hill, we'll see you on June 2nd, sir. And Mr. Philippa, who else do you have here?
I have Mr. Johnson, but not for another hour, maybe.
Okay, is he in custody or?
He is out of custody.
Okay,
I haven't seen him in the courtroom yet.
okay. All right, Mr. Keo. All right, we can call People v. Kraft. I see. So Myers is in the waiting room? I don't see Mr. Gurmurthy though. Okay. All right, this is People of the State of Michigan versus Russell Kraft, file 25-6988 FH. Counsel, you want to state your appearances, please, beginning with the people?
Melissa Goodrich, one kind of prosecutor.
William Key on behalf of Russell James Kraft, defendant.
All right, and we're here for sentencing on a charge of felonious assault, a 4-year felony. The guideline range was initially scored at 0 to 9 months. Mr. Keo, have you had a chance to review the report and recommendations with you?
I have, Your Honor. We reviewed it. No objection to the narrative portion or the scoring of this one.
Ms. Goodrich, any from the people?
No, Your Honor.
Okay, Mr. Keo, I would indicate I had an opportunity to review a letter submitted from Ronan Psychological Associates regarding Mr. Kraft's progress. So go ahead with anything you'd like to say on your point.
Thank you, Your Honor. I think when you take a look at this case, what we really have is a mental health crisis. Court is obviously aware of some of the factual basis of this case. Happened on Christmas Day quite some time ago, and I think there was a situation where my client had ideation, and there were thoughts of ending his own life that day. And I think when the victim confronted my client that day, say confront when he had contact with my client that day, it set off a chain reaction based on where my client was mentally that day. I'm glad the court has had an opportunity to review the mental health records from Mr. Kraft and some of the medicine that he's currently taking to address those problems. He's been on bond for quite some time in this case, and he's done very, very well. I'd like to thank the prosecutor for making the offer in this case, and I do think that there is a path forward with the recommendations outlined in the PSI. I think that period of probation, along with mandated and reported counseling, will get him to where he needs to be mental health wise, and he can get back to living the kind of life that he's capable of living. He's a pretty accomplished person. If you take a look at some of the excellent jobs that he had a family, and now all of a sudden he's trying to put the pieces back together. So we're asking for an opportunity to allow him to do that. And I think
I don't want to, given the range and the recommendations, I don't want to kind of sandbag you. I mean, I'm giving a lot of thought to whether this is a case that, despite the scoring, calls for reasonable grounds for incarceration. So I'd like to hear your input as to that.
Well, Your Honor, I think that I could probably concede that there are some things that are not taken into account in the guidelines based on some of the specifics. What I want the court to consider is rather the way the act was committed versus what was going on in the mind of my client at that time. I think when I look at a case like this and I look at the act itself, there's a lot to be not only concerned with, but horrified by, quite frankly. I totally understand the court's concern and what the victim had to deal with at that particular time. But I remember one of the first lessons I learned in law school was mens rea. And what's going on in somebody's mind at the time they commit an act. What is actually their motive? What exactly is going on in their mind? And I think what was going on in my client's mind was that he was not of sound, that this was somebody who was having a mental breakdown, who moments before was thinking about taking his own life. This was somebody who was on Christmas Day looking at the shattering of his entire world, was thinking about ending everything. Obviously, we don't defend any of what he did that day. But I think what happened that day was just a complete and utter mental breakdown. And if you take a look at his history, he's not a violent person. I think what he did that day was violent, but I think it was a result of mental health, complete deterioration versus say any kind of intent to be violent per se.
Great, thank you, Mr. Keel.
Thank you.
Mr. Kraft, you don't have to make a statement today. If you choose not to, I don't hold that against you at all, but you're also welcome to tell me anything you wish. Is there anything you want to say, sir?
Your Honor, I regret my actions that day. I do wish to apologize to you for the mistakes. I was going through a tremendous amount of life changes and affected me very negatively. So I just appreciate the court's time.
All right, thank you, sir. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. We're here because on Christmas Day in 2024, the victim was exiting a gas station and wished defendant a Merry Christmas while holding the door for him. The defendant nearly hit him in the face while he flipped him off and yelled at him. The defendant then pursued him out to his vehicle and possessed a circular saw that was running and tried to cut him, or pretended he was going to. And then the defendant tried to hit the victim with his vehicle, which was caught on video. The defendant is 46 years old. His first arrest was at 43 years old. That was for stalking. He served 10 days in jail on that case and was discharged unsuccessful because he incurred this offense. He has 0 prior felonies and 1 prior misdemeanor. He's unemployed with a bachelor's degree. He has served 31 days. Due to the severity of the offense, the level of threat of physical harm and public safety concerning acting in a dangerous manner, that like he did that night towards an innocent member of the community who was just trying to be polite. I think that mid guideline range is appropriate here. Defendant could continue his mental health medication regime while incarcerated. I do commend him for addressing his mental health issues. But he did have the same resources back then. He was already under court jurisdiction and encountered the law prior to this incident happening. And he did cause trauma to an innocent person who now has to live with what happened for the rest of his life. Thank you.
Thank you. Mr. Kraft, if you please stand for the court sentence. This is a troubling incident, and I know that mental health did play a role in what happened that day, as your attorney has well articulated and is documented in the PSI and the previous evaluations that I've considered in this case. But even when you're going through some depression crisis, random people on the street are entitled to go about their day without fear that somebody's going to push them in front of a subway like we see on the news different places, or assault them with a saw like you did that day just for wishing you Merry Christmas. On Christmas Day, I know you take that the very wrong way, but that's a normal thing. It could have been anybody in the world doing that day, trying to just be courteous to you. And you reciprocate by a very frightening incident for that person. So I know that you were going through a depressive incident and we're in a suicidal state, but I think that's the public still demands that they be able to go to the gas station on Christmas Day and wish someone Merry Christmas without being assaulted. And I think that justice does require some punishment for that, not just the rehabilitation efforts on probation. I think we have to balance all those things. If I was just looking at pure punishment, this is the kind of event that I would send somebody to prison for. You need to know that. And the charges that you were facing could have definitely ended up there. So your attorney's done a great job with presenting, what's been going on with you so that the prosecutor could take that into account. And for that reason, you're not going to prison today. And I don't think that we need to overdo a jail sanction. But I do think that there is some reasonable grounds for incarceration given the seriousness of the incident and the demands of public safety. Taking all those things into account, I am going to place you on probation as recommended. It'll be for a 2-year initial term, not 18 months. I think I want it to be a 2-year initial term just so we can make sure we follow up that you're staying in a better spot with your mental health, okay? Some of the terms that you're subject to, all the terms listed on page 2 in the pre-sentence report. I want to highlight some of those. You have to take medication as prescribed and complete treatment as recommended. There is a curfew. You have to maintain employment. There's a crime victims assessment of $130, $350 in court costs, which is well below the average per case cost as calculated by the State Court Administrator's Office. $60 DNA testing fee and comply with testing, $68 state cost, a monthly supervision fee to the Department of Corrections. And I think that I'll also sentence you to serve 4 months in the Sheboygan County Jail with credit for 31 days previously served. That's a bit shy of the midpoint of the guideline range that the prosecutor recommended, which I think is a fair recommendation. I think it's measured and appropriate, and it's nowhere near the top end of that as well. Mr. Kraft, you can petition for early discharge from probation at the halfway point if you've complied. We're going to hand you a piece of paper about that. Also, you can appeal if you wish by filing an application to the Court of Appeals. We're going to hand you a piece of paper about that. If you want a lawyer, you'd have to ask within 6 months. We're going to ask you to initial the appeal paperwork for us. So we have a copy of the record we gave it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions? Within 24 hours of your release, you have to contact your supervising agent, and I imagine supervision will be transferred down to Isabella County where you live. But you will have to serve that sentence forthwith. Okay. Good luck to you, Mr. Kraft.
This courtroom session showed two very different sides of the justice system. In Samuel Hill's case, the court accepted a no-contest plea in a felony domestic violence matter. But the judge made one thing crystal clear: plea deals are conditional, and one mistake before sentencing could completely change the outcome. Then came Russell Kraft's sentencing, where the court had to balance mental health struggles against public safety after a terrifying Christmas Day confrontation involving a running saw and an alleged vehicle attack. The judge acknowledged the defendant's psychological crisis, but also reminded everyone that innocent people still deserve protection no matter what someone is going through mentally. In the end, the court chose probation with treatment requirements, but still imposed jail time to reflect the seriousness of the offense. Now the big question is, do you think the sentence was fair, or should the punishment have been harsher? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.